Hello, good evening, Adisha. Hello, am I audible?
Yes, sir.
Okay, okay, thank you. Hello, good evening, sir. Shailesh, sir. Welcome, sir.
Good evening to you and to all the participants.
Yeah, sir. Thank you very much for joining. Sir, yes, sir. Sir, are you able to present Hardik, sir? Please make
I can
sure.
present it or let the host present it, if you can share.
Uh, yeah. So
I
please
think you
try
have to
now,
share.
sir. You're a sir presenter.
I'm the presenter, so how do I present?
Sir, please open your PPT and then there is a button called share in bottom.
Yes,
First, open the PPT and then click on share. Then window will come up. So you can select and then, sir.
can you see my PPT?
No, sir, not now. No, no, sir.
I think I've got it. I'm used to Zoom. I'm not used to WebEx.
Yeah, no, no problem, sir. Sir, have you opened the document, PPT document?
Yes,
Okay, then sir, go to share and then on share, click to window. Then you can select, sir.
I'm doing share, and it's giving me a. Can you share it? Can you or somebody else share it?
Yes, sir, 1 second, I'm doing.
I think that will be better.
Yeah, no, no problem, sir. I'm just 1 second, sir. By the time, Payal, you can introduce, sir. So I'm just opening
Sure.
the PPT.
Okay. I'll
Yes,
start
sir.
first.
Sir,
3 4 minutes.
so give me 1 minute for introduction. Payal, over to you, sir.
Go ahead.
Good evening, everyone. My name is Payal Dalal, and I'm currently pursuing BLLB. I welcome you all to fifth edition of online short-term course on legal aid and allied laws, organized by Pro Bono India in collaboration with Pro Bono Club, JNLU Gandhinagar. Today is the seventh day of the short-term course on legal aid and allied laws, and today's session is on understanding the RTI Act. It is my utmost privilege to extend a warm welcome to Shri Shailesh Gandhi. He is a former Central Information Commissioner. He is a first generation entrepreneur. He sold his company to become a RTI activist. Shailesh was a part of National RTI movement, which was involved in drafting the National Act. He was the convener of National Campaign for People's Right to Information. He has used RTI and also trained many citizens and government officials in over thousands workshops to use it. The only RTI activist to have been chosen as the Central Information Commissioner. He disposed a record of over 20,000 cases in 3 years and 9 months and ensured that most cases were decided in less than 90 days. He gave many landmark decisions on RTI, apart from organizing the first digital paperless office in the Commission. We are honored to have Sri Shailesh Gandhi with us today to share his invaluable insights on understanding the RTI Act. Let's welcome Sri Shailesh Gandhi to the virtual dice. Over to you, sir.
Shall I start? Kalpesh, shall I start? Hello? Hello? Ms. Dalal, shall I start?
Yes, sir. Yes, sir.
Okay. We claim India is the world's largest democracy. When I was in school, I was taught that democracy is rule of the people, for the people, by the people. If any of you goes to a government office, unless you know somebody there, are you treated as if you are the ruler of this country? And the unanimous answer is no. Then how are we a democracy? Are we a sham democracy? My submission to you is we call ourselves the world's largest democracy because we have a reasonably fair system of elections by which we are able to change governments, leaders, etc., and our representatives. But beyond that, we lack an essential part of democracy. A fair system of elections and a constitution are necessary conditions for a democracy, but are not the complete set of conditions. The heart and essence of democracy is the concept that each individual is a sovereign in her own right, and she gives a part of the sovereignty to the state, in return for which she gets the rule of law. Sovereignty of the individual is the key to democracy. Without that, democracy does not exist. It's a sham democracy. All of you, my friends, should feel like the Badshah or Begums of India. That is what a democratic nation means. One young student somewhere once told me, he said, "Sir, are you serious about this?" I said, "Yes." He said, "With 140 crore Badshahs and Begums, how can a country run?" What I mean by Badshahs and Begums and what I mean by democracy is empowerment of the citizen, the individual citizen. Let me give you two examples of that. One is in the United States of America. I'm not saying everything is perfect there. In fact, they have Mr. Trump. But by and large, if any immigrant from India, Pakistan, Bangladesh, China, who has applied for the green card or citizenship of the United States, calls up and asks about the status of his application, 99% he or she will get a fairly rational answer from the other side of the telephone. You are all first-rate citizens of India. If you have applied for a change of address in your ration card and you don't get a response, chances are none of you will try and use the telephone. Most of you will go to that office and have a 50% chance of getting a rational answer from the other side. This is what I meant by empowerment of a citizen being, a human being being treated with respect. The second example I'm going to give you is a story all of you have heard, but I'm going to give it with a slightly different perception. Mohandas Karamchand Gandhi got inside that train in South Africa about 150 years back. He had a first class ticket. He got inside the coach of first class. The white man objected and he was thrown off the train. In the same story is written that Mohandas Karamchand Gandhi sent a telegram complaining about what had happened to him. 125 years back, at night, Mohandas Karamchand Gandhi, without any mobile, without any telephones, he used the telegram. And in 12 to 15 hours, a railway official came and put him on the next train. Think of the significance of this. Mohandas Karamchand Gandhi was not a South African citizen. By South African law, then he was a second-rate human being because he was a brown man. Despite that, the system responded because one human being had called. I need not describe to you what will happen in today's Indian Railways if you filed a complaint. In 12 to 15 days, if you got an acknowledgement, you will consider yourself lucky. This is what I meant by empowerment of the citizen, each one being a king or queen. Because you are a human being, you deserve certain respect and that must be given to you. In theory and our constitution, it's laid down, but in actual practice, it's flouted everywhere. The first transparency law was introduced in Sweden on 2nd December 1776, nearly 250 years back. After that, for nearly a century, no other country had such a law. In the last 1 century now, about 130 countries have introduced such a law, which is now going with 3 different names worldwide. Access to information, ATI, freedom of information, FOI, and RTI, right to information. All these 3 are synonymous words. What we're going to do today, my friends, is first and foremost, begin to feel like the king and queen of India. The Raja or Rani hai, if you believe that, the rest is automatic. One student, again, in another college, got up and asked me, he said, Mr. Gandhi, are you serious? I said, yes, I am. He said, do you really mean I am the ruler of this country? I said, yes, you are. So supposing I like a government car, can I take it home? I said, you can't take it home. So he said, sir, aap jhoot bolte hain. If I'm the ruler of India, I should be able to take a car that I like home. I explained to him that if he took the car away, he is in partnership with 140 crore other Indians. Therefore, it would deprive the other 140 crore citizens of India. But, and this is important to understand, all the information in the files, computers, etc. of the government also belongs to you. You own it. The default mode in RTI is everything is available, all information is available to you because you're the owner of the information. Only some information is barred because for practical reasons, some information cannot be parted. But nobody can say this is confidential information, hence I will not give it to you. Such a concept does not exist in RTI. Now, what we're going to do today is learn some of the provisions of the Act, how to use it. And by the end of this, if you start feeling that you are the king or queen of India, I guarantee you, you can make a better India. You can contribute very significantly. Next slide, please. No, what I'm seeing is I'm not seeing the presentation. Kalpesh, is the presentation on?
Kalpesh sir, you are on mute.
I'm on mute.
Not you, sir. Kalpesh sir is on mute.
I think so. You are unmuting yourself from another device.
Can I see the presentation, please? And can all of us see the presentation?
So we are able to see the presentation.
How do I see the presentation?
Sir, I'm just again uploading the PPT, sir.
Sorry? How do I see the presentation?
So 1 second, I'm again uploading the PPT. So is this visible? File?
Yes, sir, it is.
Yes, sir.
What should I do to make it visible for me?
Sir, is it visible?
Yes, now it's visible. Make it slightly bigger, please. The preamble is being displayed. Am I right?
Yes,
You're
sir.
displaying the preamble. Okay.
Yes, sir. Preamble. Yes, sir.
The preamble of a law tells you its purpose and objective. And it's very important to understand this. Whereas the Constitution of India is established democratic republic, and whereas democracy requires an informed citizenry and transparency of information, which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the government. And whereas revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the governments, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. The harmonization is being done by Parliament. It is not left to individuals to harmonize. Some people, some commissioners and some other people say it has to be harmonized. What this preamble means is it's already harmonized in the law. When did we get the right to information? Article 19A, 1A gives us freedom of speech and expression. And the Supreme Court since 1975 has accepted that RTI is part of Article 19(1)(a). Freedom of speech and expression includes right to information of the citizens. Therefore, what the RTI Act does in 2005 is only codifying your right, giving you a practical means of enforcing that right. Next slide, please. What is information? Information means any material. You can take a look at that. In simple terms, information must exist. What exists is information. What does not exist is not information. For example, if you ask, what is the meaning of the law? If I apply for this job, will I get it? Why did you act like this? The official is only bound to give you what exists on records. So if you ask what is the meaning of this law, unless there is a record which says what the meaning of the law is, the public information officer is not expected to give you any information. Next slide, please. Who has to give information? Public authorities as defined by the RTI Act. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution by any other law made by Parliament, by any other law made by state legislature. A, B, and C effectively covers everything that we normally call government. Central government, state government, panchayats, municipal corporations, municipal bodies. All of these are covered by A, B, and C. By any other law, by notification issued or order made by the appropriate government. If an institution comes about by notification issued by the appropriate government. For example, all deemed universities are created by a notification issued by government. Therefore, they are all covered under RTI and are public authorities. And includes any body owned, controlled, or substantially financed, non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. If money is put in by government in substantial amount to any body, by virtue of this, all aided schools and colleges are public authorities and have to give information. The key principle is the money belongs to me. I, the king or queen of India. I, the Maharaja or Maharani of India. I, the Badshah or Begum of India. Therefore, if I spend money, I must get my hisab. Next slide, please. What does right to information signify? Right to information means the right to information accessible under this Act, which is held by or under the control of any public authority. If a public authority holds information or controls some information, then it is to be provided by them. Includes the right to inspection of work document records. You can inspect work also. You can go and inspect a government hospital. If a road is potholed and the government records doesn't show that, the municipal records don't show that, you can ask for an inspection of the road, inspect the road with a municipal officer and record and photograph. That becomes part of record. Taking notes, extracts, or certified copies of documents or records. That is what most of the time is done. 90% of the RTI users are using it to get copies of records, copies of files, etc. Taking certified samples of material. This can be an important way of using RTI. If you believe that concrete being used in a government work is substandard, you can take a sample and get it tested. If you believe the government hospital is giving substandard drugs, you can take a sample and get it tested. Or food grains, for example. Obtaining information in the form of diskettes, floppies, etc., etc. CCTV footage is an equal part in terms of form. And this will increasingly become an important source of information because we've got CCTVs installed in a lot of cities, a lot of roads, many public places, including police stations. So CCTV footage is a very important aspect of information, of the right to information, getting access to that. Next slide, please. Section 4, this is supposed to be the heart of the RTI Act. It is very poor in implementation. Maintain all its records. Every public authority shall maintain all its records. No, please go back. Duly record, cataloged and indexed in a manner and form. Please go back.
One second, sir. Yes, sir. Section 4, sir.
Section 4, yes. What I'm seeing is section 3.
Now, sir.
Now it's there. Maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this act and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country on different systems so that access to such records is facilitated. It's nearly 20 years since the act was promulgated. This has been very poorly executed, very, very poorly. A normal example is a citizen goes to a government office to pursue his complaint or representation or application, and he or she may be told फाइल नहीं मिलता है, 100 रुपए दिया तो फाइल मिल जाएगी, 500 दिया तो रिकॉर्ड बंदी हो जाएगा, 1000 दिया तो फाइल गायब हो जाएगी, और थोड़े लाख रुपए दे तो मंत्रालय में आग लग जाएगी. This is what is happening with paper being used for all transactions. A file has to physically travel from office to office, and during this pilgrimage, records can be changed, mutilated, lost. This is a very common example of how things are happening. The dream would be everywhere computers are there. All village panchayats also have computers now with reasonable connectivity and the person who can operate a computer. If most of the correspondence is done on the computer, it's being used as an electric typewriter. If a file was made on a computer and transferred to another office, it can happen in seconds, whereas today it takes days for a file to travel with all attendant problems. Secondly, the amount of paper we waste runs into crores of rupees, thousands of crores of rupees, plus the space required for it and the effort to locate these files. It's all a huge waste. I'm dreaming of a situation where we use only computer electronic files, and that would actually resolve a lot of problems. And the ideal state would be where every evening the work done by an office goes up on the website automatically. That would be true transparency, true empowerment of citizens. Next slide, please. There are 17 points under section 4.1b, 17 such other information as may be prescribed. The heart of the RTI Act, unsatisfactory implementation, very poor implementation. Computerization is a key to this. And we have computers and we have lots of people using computers. Proper implementation would improve working efficiency. It will also make the PIO's job easier. Over 50% RTI applications seek information which should be available suo motu under section 4. Next slide, please. Okay, now we understood what is right to information, what is information, who has to give information. But where do we go? Who do we ask? How do we find out the name of the officer who will give us the information? The law has made it very simple. You are the sovereign. You do not go from table to table. You think of where the information that you are seeking is likely to be and file an application to the public information officer at that office. The law says every administrative unit of a public authority must have a public information officer. This officer is usually doing some other work also, and he is also doubling up as the public information officer. Next slide, please. A person who desires to obtain any information under this act shall make a request in writing or through electronic means in English or Hindi or in the official language in the area. So he can make an application in any one of the 3 languages, English, Hindi, or the official language of the state. The response may come in whatever language the office is familiar with. You cannot say, since I have applied in Hindi, respond to me in Hindi. An applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting you. You do not have to give any reasons. Some government officers say this is unreasonable. It is not unreasonable. This is my fundamental right. You have to give reasons for seeking information. Tomorrow I'll have to give reasons for speaking. Tomorrow I have to give a reason for painting, to make a poem, to publish something. All these are covered under Article 19(1)(a), and no reasons need to be given by a citizen. This is a mistake a lot of public information officers, even commissioners and judges are making. They seek reasons why a person wants information. This is absolutely wrong and goes against the principles of what are fundamental rights. Fundamental rights are human rights. They belong to me because I'm a human being. Next slide, please. On receipt of a request under Section 6, PIO shall as expeditiously as possible in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in Sections 8 and 9. The only reasons for rejection have to be in Sections 8 and 9. Section 9 covers copyright, which is very rare case, so I will not cover that. Section 8 has 10 exemption clauses, which must be carefully understood. And we'll deal with those sections in a short while. If PIO, but nobody can say this is confidential or this is ongoing matter, therefore I will not part of the information. That is just not accepted in the RTI. If PIO fails to give decision on the request for information within the period specified under subsection 1, the PIO shall be deemed to have refused the request. And taken with section 20, it means refuse the request without reasonable cause. And it provides the penal provisions of the law. We'll come to the penal provisions later. Next slide, please. There is some fee that can be charged. Normally for an RTI application, in most cases, it is 10 rupees. In a lot of places, in a lot of states and the central government, you can pay it with an Indian postal order of 10 rupees, which is available at most post offices. Some states have port fee stamp also acceptable, like Maharashtra has port fee stamp is acceptable payment. Or of course, you cash into that office. If information has to be provided, say it's 100 pages, the PIO can charge you 2 rupees per page. That is 200 rupees. So the PIO will inform you that the information you are seeking is 150 pages or 200 pages. Therefore, please pay this amount. And within 30 days, information has to be provided to you. Person making request for information shall be provided the information free of charge when a public authority fails to comply with the types which specified in subsection 1 is 30 days. If within 30 days the information is not supplied to you, no further fee can be charged. Here the information is 1,000 pages. The PIO cannot charge you 2,000 rupees. He has to give the information free of cost. You are the owner of the information. You are the king or queen of this nation. Next slide, please. The 30-day period I just wanted to explain to you. PIO receives RT application day 1. After X days, PIO sends letter asking additional fees, 30-day clock stops. Additional fees paid, 30-day clock starts again. Information sent after Y days, X plus Y should be less than or equal to 30 days. If, supposing you ask a department, it does not have the information, but it's in a completely different department. Within the department, the PIO is expected to gather the information from various people and send it to you. But if it's in a completely different department, for example, supposing you thought the information is in the municipal, is anyone saying anything? To believe that information was available in the municipal office, you applied to the municipal office, the actual information is available with housing department. Can the PIO refuse information and tell you no, udhar jao? The answer is no. This law recognizes your sovereignty, your importance, empowered citizen. He has to transfer the application to the other office and inform you about it. So if such a transfer occurs, if RT application is transferred, 35 days is the limit. 5 days are given for transferring the RT application. Next slide, please. These are some samples of RT applications that I have. What's a good RT application? Normally, it should be brief. Though you don't have to give reasons, there is some reason that you are seeking information. It may be because you suspect corruption. It may be because you want to uncover some wrongdoing. It may be because your normal application for something is stuck. It could be because you believe that you want certain information about government working. A good RT application specifies the information that is sought. And it should be such that immediately you will get what you want. So these are samples of RTI applications. Next two slides are for that. I have requested Mr. Gupta to share this PPT with you. You can take a look at it. Next slide, please. Okay, the last one is slightly worth thinking of. Sorry, previous slide, please. In case you want to inspect files, you can inspect files also. This is quite often useful. Then the application can be something like this. I want to inspect files relating to whatever topic or file numbers you can give if you know the file numbers. I'll bring Mr. So-and-so to assist me in the inspection. Please suggest 2 dates with time at which I could come for the inspection. I will identify the documents for which I want photocopies at the time of inspection. Please ensure that the pages of the file are numbered. If you are offered a file at inspection which are with pages which are not numbered, don't accept the inspection. Write down that numbers are not there. Therefore, this is not acceptable. All government files must have page numbering. Next slide, please. Likely outcomes of RT application. PIO sends letter asking for further fees to be paid and the information obtained by the applicant satisfactory outcome. You get letter from PIO transferring your application. Further communication with the PIO to whom the RTI is transferred. Do not ask the first PIO. He will inform you he's transferring it to so-and-so department, so-and-so PIO. So deal with that. You get letter from PIO refusing to give information, quoting an exemption. If you feel exemption is justified, accept the decision. If you feel refusal is not justified, file a first appeal within 30 days. You must state reasons why you think refusal is not justified. PIO asks you to come for an inspection. If information is clearly there, separately available, then you should not ask you to come for inspection. PIO does not respond at all. This is a deemed refusal without any reason. File a first appeal after 35 days and before 60 days of the RT application. Address to the first appellate authority, care of public information officer. Please not, the law requires him to inform you whenever he is rejecting your RT application or responding to your RT application, giving you details to the first appellate authority. The first appellate authority is a senior officer compared to the PIO. But supposing he doesn't respond to you at all, then how do you know who the first appellate authority is? For that, use a simple technique. Appeal to the first appellate authority, care of public information officer at the same address. And below that, write that the law requires you to give me the details to the appellate authority. Since you have not done that, now you must transfer it to, now you must send it, forward it to the first appellate authority. Next slide, please. This is very important to understand. What are fundamental rights? Fundamental rights are human rights which accrue to us because we are a human being. They are not to be mixed. Other rights are also important. But the fundamental right is one which accrues and is universal to the world in a way. Freedom of speech is universally there in all countries that claim to have democracies. RTI is a fundamental right of citizens under Article 19(1)(a), which guarantees freedom of speech and expression. A variety of Supreme Court judgments have held that this includes right to information and right to publish. This is something I want to stress to you. Everybody says media is a very important factor of democracy. It's the fourth pillar of democracy. Why is media so important? Media is not even mentioned in the Constitution of India. But why is it so important? Supreme Court has ruled various times that it is a medium through which citizens get information. So think carefully. Because media is a medium through which I get information, media is important. My right to information cannot be lower than media's right. My right to information is equal to the media's right. The only permissible restrictions are given in Article 19(2). If any restrictions have to be put on my fundamental right, they have to be in the Constitution. Article 19(2) gives restrictions, permissible restrictions, which permits reasonable restrictions in the interest of the sovereignty and integrity of India, the security of state, friendly relations with foreign states, public order, decency or morality, all in relation to contempt of court, defamation, or incitement to an offense. I'd like to draw your attention here to the fact that privacy is made out into a big deal. There are only two words in Article 19(2) that relate to privacy: decency or morality. If disclosure of some information violates decency or morality, then it should not be given. Otherwise, the law is very clear, which is now being subverted by various means. We'll deal with that when we come to these sections. Next slide, please. Exemption from disclosure of information, section 8.1. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relations with foreign state, or lead to incitement of an offense. This is a mouthful. But PIO is not expected to only say, I'm rejecting because of 8.1. He must identify what interest is likely to be hurt. And for example, supposing in the RTI you ask what are the troop movements in the Galwan Valley, this will be denied to you because if giving it would affect the sovereignty of India. But note carefully, nobody can say this is sensitive information or confidential information. He must justify it by the harm it is likely to cause. B. Information which has been expressly forbidden to be published by any court of law, tribunal, or the disclosure of which may constitute contempt of court. Some people have claimed this exemption when it matter is sub judice. Sub judice is not a cause for exemption. Parliament has specifically said expressly forbidden to be published by any court of law or tribunal. Therefore, there should be an express provision in a court order saying that this information shall not be parted with. All the disclosure of which may constitute contempt of court, sub judice matters can be disclosed. Only thing is, supposing a hearing is being held in camera, then publishing that would constitute contempt of court. Information, the disclosure of which would cause a breach of privilege of Parliament to the state legislature. For example, budget papers before they are presented to Parliament or state legislature cannot be parted with. Similarly, commissions of inquiry reports. According to the Commissions of Inquiry Act, within 6 months they have to be placed on the floor of Assembly or Parliament, depending on which government is involved. Before that period is over, if you ask for information and the matter is not placed on the table of the Parliament, then they can claim exemption. Next slide, please. D. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party. There is a larger public interest override which we'll deal with together at the end of this. Two conditions have to be satisfied. It is in the nature of commercial confidence, trade secret, or intellectual property, and disclosure should harm somebody's competitive position. For example, if you ask for the formulation of Coca-Cola, if it is with FDA, they cannot give it to you because it is of the nature of commercial confidence and would hurt the commercial interests. But this is important to understand. Tenders that are given, after the tender is awarded, this information must be given to you because you cannot say that somebody's competitive interest will be hurt. Information available to a person is fiduciary relationship. What is a fiduciary relationship? There's a lot of back and forth on this. Let me spell out for what are traditional fiduciary relationships: lawyer, client, doctor, patient, banker, customer, trustee, trust. These are the traditional fiduciary relationships. What are the characteristics of this? A, you give information to a fiduciary for your benefit. It is not for statutory duty. You give it out of your volition. You want to do it, you give it. You can choose who your fiduciary is. You can choose your banker, your lawyer, your doctor. C, the fiduciary is supposed to act in your benefit. 90% or 95% of the information with governments is not held in a fiduciary relationship. For example, a bank holds your information in fiduciary relationship because he's your banker. You have a choice of which bank to go to. But this is often, I've seen people claiming that government को दिया तो fiduciary relationship हो गया. बिल्कुल नहीं. In fact, most information that is provided by a citizen to a government is in a statutory relationship. Information received in confidence from foreign government. This is the only place where the word confidence or confidentiality comes in. If information is provided by a foreign government, the PIO claims it's given in confidence. The matter ends there is no further discussion on this. Information, the disclosure of which would endanger the life or physical safety of any person or identifies as source of information or assistance given in confidence for law enforcement or security purposes. If releasing some information is likely to endanger somebody's life or physical safety, then of course this cannot be given. Next slide, please. Information which would impede the process of investigation or apprehension of prosecution of offenders. Quite often, wrongly, PIOs refuse to give information saying the investigation of process is not complete. That's illegal. Parliament used the word impede the process of investigation, which means it was assumed that even while an investigation is ongoing, information should be provided unless it can be shown that it will impede. A lot of times, people are asking, they find a complaint and they know nothing is being done or they feel nothing is being done. So they ask, what is the progress of my complaint? And this is held up and saying investigation is going on. That's an illegal denial of information and you should fight it in an appeal. Saying that Parliament used the word impede. Otherwise, they could have said when an investigation is ongoing, information shall not be provided. Cabinet papers, including records of deliberations of the councils of ministers, secretaries, and other officers, provided that the decisions of the council of ministers, the reasons thereof, and the particular on the basis of the decision taken, shall be made public after the decision has been taken and the matter is completely over. This is a unique exemption. Until a certain time, the information is exempt, until the decision is taken by a cabinet. But once a decision is taken by the cabinet, for example, if a new law is to be enacted, then it presumes that while the decision is being taken, the information will not be shared. But once a bill is tabled in Parliament or state legislature, then it is incumbent on the government to open up and show the whole process of decision making. The whole concept is you are the Badshah or Begum. Citizens must be able to discuss laws and bills that the government brings in. And you will give legitimacy to Parliament and state legislature, not the other way around. This is a very unique and very useful exemption. Next slide, please. J is the most popular exemption used by PIOs. Misused, I would submit, by PIOs, commissioners, and judges. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the override of the public interest I will deal with later, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. Carefully read what this means. If it's personal information, it may fall under 8.1J. May. All personal information cannot be under 8.1J. The disclosure of which has no relationship to any public activity or interest. 90% of the documents in a government office are the consequence of a public activity, not a private activity. What you do in your house is a private activity. What you deal with government is a public activity. Your income tax return, except the things that you, if supposing you go to a government hospital and your records are there, that's a private activity. That's, you're not forced to do it there. Or which would cause unwarranted invasion of the privacy of the individual. Now, this is the conundrum. What is privacy? The Puttaswamy judgment in a 550-page order has said privacy is a fundamental right of citizens, but not defined what an average officer can be able to interpret as to what constitutes privacy. In my opinion, Article 19.2 should be taken as base and what constitutes violation of decency or morality should be denied. All of the information should be given. Another way around is the government permitted to intrude my privacy in a routine manner? The obvious answer is no. So any information the government seeks from me in a routine manner, cannot be considered an invasion of privacy. Because it was understood by Parliament that this conundrum would be very difficult to resolve for an ordinary public information officer, even an appellate authority. Therefore, it gave an acid test to this provision, which is this proviso. Provided the information which cannot be denied to Parliament or state legislature shall not be denied to any person. How is that to be used? In my opinion, whoever denies information claiming exemption under 8.1J must say that, in my opinion, I would not give this information to Parliament. If something violates decency or morality, it should not be given to Parliament. It should not be given to the citizen also. Parliament is given legitimacy by the citizen. You, the Bacha or Begum of this nation, are giving legitimacy to them. Therefore, what can be given to you, if it is going to cause great harm to decency or morality, it should not be given to a citizen. But without such a statement, 81J is wrongly applied. Notwithstanding anything, the Official Secrets Act nor any of the exemptions permissible in accordance with subsection 1. Public authority may allow access to information. Public interest in disclosure outweighs the harm to the protected interest. If information is exempt, then only public interest needs to be shown, not otherwise. Some people have said, show public interest in disclosure. This is required to be done only if and when an exemption applies, not otherwise, I repeat. If an exemption applies, you may still argue that no, maybe there's a larger public interest in disclosure. For example, let me give you a concrete example. Supposing you ask for transactions of Nirav Modi with Punjab National Bank. Punjab National Bank would legitimately claim fiduciary relationship and say we cannot give this information. You may argue that there's a larger public interest because a major scam has occurred. It would be weighed and then disclosure may or may not be permitted. But it is not easy to convince anybody that there's a larger public interest compared to the exemption. You should find the exemption clause itself, not try and justify it on larger public interest. That's very rare cases where you will get a positive judgment. Subject to the provisions of clauses A, C, and D, I of subsection 1, any information related to occurrence, event, or material which has taken place, occurred, or happened 20 years before the date on which any request is made shall be provided to any person making the request under that information. Does this mean information must be kept for more than 20 years? The answer is no. How long a public authority keeps information is decision that the public authority takes. But if the information is available, and 20 years have elapsed, only 3 exemptions can be claimed, A, C, and I. All the other exemptions fall behind. It's like Amitabh Bachchan's 50-50 or Kaun Banega Crorepati. 7 exemptions disappear after 20 years period. Next slide, please. The Digital Personal Data Protection Act is out to finish the RTI Act almost. We should all oppose it. The Digital Personal Data Protection Act, Section 44(3), amends RTI Act 81J thus and exempts information which relates to personal information. All the rest that I have put in red are removed. It is as if they didn't exist. Unfortunately, Supreme Court has given rulings like this in Girish Deshpande and some other judgments, about half a dozen other judgments, saying that personal information is exempt without giving any reasoning, which is wrong. Parliament had put all these words, knowingly, understanding it is a beautiful word craft. If this is done, then this will make it a right to deny information. Because most things can, what is personal? Anything related to a person is personal. The word personal means only related to a person. And what is person? Who is a person? Not just individuals. In the DPDP Act, person is normal juristic person, company, state also. So government of India is also a person. Therefore, virtually, it can mean that all information, if the PIO wants, he'll give it to you. If he doesn't want, he'll say it's personal information. 99% of the information request will be rejected, can be rejected by the PIO if this goes through. It will make it a right to deny information. DPDP Act must not override 38(2). The other problem is Section 38(2) of DPDP Act says it overrides all other acts. Now, if that happens, the public information officer will be in a conundrum. He will say, if I give this information, I may be running foul of the DPDP Act. And the DPDP Act has penalties going up to 250 crores or 500 crores. In RTI, the maximum penalty is 25,000 rupees. Let's forget the crores of rupees, but if a PIO is saddled with even 1 lakh or 2 lakh penalty under DPDP Act, who is going to take that risk? Therefore, 2 amendments should be made. One is 38(2) must not override RTI Act. And 44(3) should be, the amendment should be removed completely. 44(3) must be removed from the DPDP Act. Only then does transparency become true. Otherwise, in a few years, this will become a right to deny information, which is very, very unfortunate and a grave threat to our democracy. Next slide, please. These are arguments for what I talked about. Next slide, please. Next slide. Do read this if you have interest. Next slide, please. Section 11. When a PIO intends to disclose any information or record, there are commission orders and judicial orders which say that a matter is belonging to third party, hence it is denied. It cannot be denied. Section 11 is a procedure, it's not a denial. It's not an exemption. When a PIO intends to disclose any information or record or part thereof on a request made under this act which relates to or has been supplied by a third party and has been treated as confidential by that third party, the PIO shall within 5 days from the receipt of the request give a written notice to such third party of the request of the fact that the PIO intends to disclose the information or record or part thereof and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed. And such submission of the third party should be kept in view while taking a decision about the disclosure of information. What is the whole meaning of this? If information does not belong to the public authority, it belongs to a third party. The PIO and the whole intention behind it is the PIO may not be able to think of the exemption applying or what harm may come to a third party. Therefore, it gives the third party an occasion to interfere with giving the information. But it starts with intends to disclose the information. The PIO can intend to disclose the information when he or she is convinced that it is not exempt and that the information exists. Under such circumstances, he tells the third party that, look, if you have any objection, let me know. And if that third party can point out an exemption, then it will be denied. But the PIO's decision has to be based on the exemption, not because it's third party information or third party is third party does not have a veto of giving information. Next slide, please. Section 19, appeal. First appeal to first appellate authority within 30 days for not getting information, incomplete information or wrong information. First appellate authority should decide in 30 days. They can take another 15 days to 45 days. The result of first appeal not satisfactory, the second appeal to the commission within 90 days. Section 19.5, onus on PIO, the denial of information is justified. Strictly speaking, the law does not expect you to justify why you should get the information. You only have to show that the exemption does not apply. That is all you are expected to do. Next slide, please. Carefully look at the response and see if information has been provided. Information can only be denied if it's not available. It is exempt under section 8 or 9, file not found. If they say file not found, or they say missing file or we cannot trace the file, ask for a FIR to be filed complaining about loss of or theft of government property. If a file is lost or cannot be found, at times as a commissioner, people would say missing record. I would say file a FIR saying the file is stolen. I would say, how do you know? We are not saying it's stolen. I would say either you can locate it. If you can't locate it, it will be stolen. This pressure does help at times. Next slide, please. Next slide. Section 20 is the teeth of the act. This is the reason why the law works to whatever extent it does. If information denied without reasonable cause, Commission must penalize the PIO, DPIO, rupees 250 per day of delay after giving an opportunity of explaining. Maximum penalty of 25,000 rupees. Commission can also recommend disciplinary action against the officer and compensation to be paid to applicant. This is the teeth of the act, as I said. This is the first time in law that individual citizens' right being denied can lead to public officers having to pay a personal penalty from their salary. This recognizes the sovereignty of the individual citizen, makes it actualizes your sovereignty. Unfortunately, a lot of commissioners are very reluctant to impose penalties. It's violation of the law. If adequate penalties were imposed, I think RTI will be much stronger implemented. Next slide, please. The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act and any other timing for the law for the in force or any instrument having effect by virtue of any other law rather than this act. In short, as far as giving of information is concerned, RTI overrides all other laws and rules. This is the accepted position in law, and any such law impinging on RTI is, unless it comes later. The DPDP Act comes later, and therefore it can override RTI. Legally speaking, it's correct. It's not right because it destroys the fundamental right of citizens. But technically speaking, it can override the RTI Act. That is why we must fight to remove the overriding provision in the DPDP Act as far as RTI is concerned. Next slide, please. Section 23. This is a very important section which is very poorly understood. No court shall entertain any suit, application, or other proceeding in respect of any order made under this Act, and no such order shall be called in question otherwise than by way of appeal. The final appellate authority under this Act is the Information Commission. The courts have no jurisdiction over this. In an appeal, if you approach the High Court must reject your appeal. They use what is called writ jurisdiction, which is available only for fundamental rights, implementation of fundamental rights. And there are 2 or 3 Supreme Court decisions spelling out what a writ can constitute. Everything cannot be called a writ. For example, a PIO going and complaining about his penalty cannot form a writ jurisdiction, and an order should never be stayed because no unfortunate harm will come to such a person which cannot be replaced. The penalty can be paid by the government if it's wrongly levied. The government, in my opinion, cannot ask for writ jurisdiction. It has no standing. Writ jurisdiction is only for individuals to enforce their fundamental rights. Government has no fundamental right. Companies have no fundamental rights. Next section. Next slide, please. Therefore, in my opinion, most of the cases in courts stopping a disclosure of information are wrong. This, in a brief, I have given RT application information 30 days. If no response provided or unsatisfactory response, first appeal to be filed in 30 days of response or 60 days in case of no response. First appellate authority order after hearing within 45 days. Unsatisfactory order or no response, second appeal to commission within 90 days of the first appellate authority order or 120 days from the date of first appeal if no order received from the first appellate authority. Next slide, please. Okay, I'm now going to relate 2 examples to you, live examples. One is, this is a young boy from Bihar who had come to Mumbai for a job. He was staying in a Chopra with his uncle. While he was going around, he heard of an RTI workshop somewhere in the Basti. So he went and sat down, like you are doing just now, and understood what is the right to information, what is information. Information can only seek records, cannot question people. It's not right to investigation or right to interrogation. It's right to information. Understood all this, he moved on. He got a job and then he needed a ration card. So he went to the rationing office, gave his form. While he was going out of the door, the peon accosted him and said, "Aapko ration card chahiye kya?" He said, "Haan bhai, isliye to form bhare." The peon said, "Chai pani lagega." The boy said, "Theek hai, aapko chai pila dunga." The peon said, "Nahi, chai pilane ki baat nahi hai." He said, "What do you mean?" The peon said, "You'll have to pay 2,000 rupees. Only then will you get a ration card." The boy made a statement that always makes me feel very proud. He said, "Bhai, goose nahi dunga. I shall not give a bribe." The peon said, "Okay, go. You come from Lalu's Raj. You don't understand how things work in Mumbai. तुमको इस जन्म में ration card नहीं मिलेगा." This boy went back, found out in the Basti, people were paying bribes and getting the ration card in about 40-45 days. He waited 3 months, and after 3 months, he gave this application. I given an application for a ration card on 5th August 2006, photocopy of receipt attached. I want the following information about its progress in the following format. Next slide, please. date on which application received, name and designation of the officer receiving it, action taken, date on which forwarded to next officer office. Will be as many rows as the number of officers who handle the application. I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made and the dates on which the ration cards were issued. This is information that has to be on the records. Now, what could they tell him? If they told him the truth, it would show corruption in the rationing office. The next day, the peon came to his house and said, "Aapko सामने बुलाया hai." This boy went to the rationing office. As soon as he entered, the officer said, "अरे अरे ये आए हैं, इनके लिए कुर्सी लेके आओ और इनका राशन कार्ड लेके आओ और एक कप चाय और एक गिलास पानी लेके आओ." He did not give chai pani, he got chai pani instead. And to me, that 1 cup of tea and 1 cup of glass of water represent respect for the individual sovereign citizen of this nation. It's far more than just getting a ration card. This technique, this line has been adopted in numerous cases for handling complaints, for representations, for getting refunds, for getting pensions, and so on and so forth. With slight modification, this format is used in lots of places. And it empowers the ordinary citizen who has no voice. RTI is a citizen empowerment tool of great importance. Next slide, please. Now, I'm going to show you the power of RTI and how it can achieve and what it can achieve. This is my own RTI application. This was done before I was a commissioner. I was just an ordinary citizen of Mumbai. Nobody knew me. One fine day in the Times of India on the front page, I saw a news report saying that citizens were demonstrating because a police constable More had raped a minor. On the same day, on page 5, there was a small news report which said that Police Inspector Prakash Avre of Mumbai Police had raped a minor the earlier year. Evidence was clear. He was suspended and the case went to court. In court, they did not offer enough evidence, hence the case was dismissed. And Prakash Avre was being reinstated in service. Made me feel very angry. I said, let me use RTI. So this was the RTI application that I filed. Next slide, please. According to a news report in the Times of India dated 29 April 06, Inspector Prakash Avre has been accused of raping a minor girl in September 2005. He was acquitted by the Sessions Court in February and has been reinstated in service. I want a photocopy of the order reinstating him along with file noting based on which the decision was taken. I did not say, why are you doing this? This is wrong. And one more tip, in RTI, do not abuse or accuse anyone. Just ask for information, work like a clear person. This was rejected by the PIO and I filed a first appeal. Next slide, please. The grounds for appeal, facts of the case. I had asked for information regarding the reinstatement of Inspector Prakash Avre as per the attached application. Next slide. The PIO first sent me a letter stating that the information would be provided by Bhaikara police station. PIO Bhaikara replied by his letter of 16.5 that the information could not be provided because it was exempt under section 8.1H, which exempts information to impede the process of investigation or apprehension or prosecution of offenders. Grounds for appeal. The PIO has not shown how providing the information could impede any investigation. In fact, no investigation is being held since Prakash Avre has been reinstated. The rejection is without any basis in law. There was a very good deputy commissioner of police who was the officer. I repeat, I was just an average citizen. Nobody knew me. The deputy commissioner of police was a straightforward man. He said, "Mr. Gandhi, what could we do? The court has let him off." I said, "Sir, from my perspective, there are two possibilities. A, either Prakash Avre is guilty of the crime he is alleged to have committed, in which case reinstating him is great disservice to police force and the citizens. Alternately, Prakash Avre is innocent to the charge, in which case somebody framed him. Such a person should be punished. What is this? Nobody gets punished. No one crime occurred." He thought for a while and said, "Mr. Gandhi, let me see what I can do." I came away. In 20 days, I got in writing from the police commissioner's office in Mumbai that Police Inspector Prakash Avre had been dismissed from service. That is the power of right to information that any ordinary citizen can exercise. Does it happen every time? The answer is no. I'd be lying if I said that. In my opinion, about 10 to 15% of the times, some small change occurs in the government or governance structure. Only 10-15% of the time, not the other times. According to a survey of mine, almost all Indian citizens script for about 1.5 hours every month about what is wrong with the country. Prime Minister is like this, President is like this, police is like this, ministers are like this, politicians are like this, professors are like this, principals are like this, and so on and so forth. Scrimming changes nothing. It can change nothing. My submission to you is consider using half an hour of that time to make one RT application about something that you feel is wrong. Don't worry whether you get a result or not. Here's a dream I want to share with you. If 60 lakh Indian citizens take a vow to file one RT application each month about what they see as wrong or where they feel some exposure is required, and don't even bother about appealing, etc., about 6 to 7 crore RT applications will be filed. 15% of that would constitute 1 crore times. 1 crore times, if things change, even in small manner, over 5 years' time, India would be a different country. It would be true democracy, true participatory democracy. You go and vote. It changes nothing. Using RTI, you can change governance, impact governance, you can impact the way society works and the government works. One old gentleman at one of my lectures, when I talked of this, he said, Mr. Gandhi, इंडिया में कुछ होता ही नहीं है. मैं 10 साल से कंप्लेंट कर रहा हूँ, रिप्रेजेंटेशन दे रहा हूँ, RTI फाइल कर रहा हूँ. इंडिया में कुछ हो ही नहीं सकता. To such friends, I say, many of us go to mandirs, masjids, gurudwaras, churches, derasars, what have you. Once in a day, once in a week, once in a year. When we go there and come out, do we have an extra 100 rupee note in our pocket? The answer is no. Do we see any physical change in our cells? Nothing. You see no connection. Why do we do it? We do it as an act of faith. We have faith that by doing this, something good will happen to me, myself, my family, my society, etc. What do we do for the nation as an act of faith? Zero. Try this as an act of faith for the nation. File one RT application once a month. If you can pursue it, but even if you can't, leave it. 60 lakh Indian citizens is not a big number. You can change the nation by participating in the democracy. Merely going and voting changes nothing. It will change nothing. Don't blame the politician for it. Blame yourself. Next slide, please. Mera Bharat Mahan, we say, it is written over tempos, trucks, taxis, etc. We don't really believe it, do we? Therefore, I say next slide. Mera Bharat Mahan nahi hai. Mera Bharat Mahan nahi hai. Next slide. But ye dosh mera hai. I, the individual sovereign citizen, am responsible. I am the king or queen of India. And if I am responsible, I must make some attempt to at least make some change. All of you are kings and queens of India. Make that effort and we can bring a change. Thank you. Thank you very much. If there are any questions, clarifications, I'd be happy to provide.
Thank you, sir, for those invaluable insights with sharing with us. If anyone is having any doubt or wanted to ask a question from our resource person, can unmute themselves and ask directly or may jot down their doubts in the chat box.
I do not believe that I have said everything that I have said is right. Challenge what I have said. I'll be happy to learn something.
Okay, any question, query, participant? Your experience?
Sir, I'm Kalpana here. Good evening, sir and everybody. Am I audible?
Yes.
Sir, I really like the way you perceive, and I have a thought of working towards doing something, some contribution from my end. So I am working on filing PIL and should not get rejected for certain reason that it has some, for some reason. I don't want to.
Breaking, ma'am. Your voice is breaking.
Sir, once I file the PIL or before filing the PIL, can I take your we want quality of the PIL files from my end, just to ensure that it doesn't get rejected from them.
Can you ask me to take a look at it? Is that what you're saying?
Yes, yes.
Yeah, sure. My email ID is given in the presentation. I'm requesting Mr. Kalpesh to, Dr. Kalpesh to send to all of you. Feel free, but keep it short. Do not make it very long.
Awesome. Thank you so much.
You're welcome.
So one question from the chat, that can we get information from private banks through RBI?
No. But information, okay, having said that, information that they submit to RBI can be accessed.
Okay, sir. Next question in the comments. Employee service records falls under the purview of RTI.
In my opinion, the answer is yes. In the view of the Supreme Court, the answer is no. The DPDP Act is actually establishing something that is de facto being done by the courts and converting into de jure, where the legal position will be that. But in my opinion, as the law stands today, this is personal information. This does not fall under any of the exemptions. You see, the talk is not can I get this or not. The talk is under what exemption is it claimed. It's claimed as personal information, which does not form, in my opinion, a raid on their privacy. But here I differ with the Supreme Court, and I'm happy to argue this matter.
Anyone else wants to ask their question? Okay. Thank you so much, sir. After the fruitful and insightful session, and we come to the end of today's session, it's time to thank everyone and our resource person. Thank you, sir. And I would like to thank our speaker and participant for being here and share their valuable time with us.
Yeah. Thank you, Shailesh sir, for joining. Again, let me tell all the participants, I've been following sir for no, like we are in touch with sir, I think since 2011. So great judgment, I would say paperless office, I would say example sir set, you know. So this is like, now we are talking about e-filing and other things, but sir set up the example 99%, I think sir, if I'm not wrong, on the spot order,
Yes,
that orders used to be
90% of the orders are given on the spot.
on the spot, sir. That was
When there
a
is
great
something,
example. Was
right? Most orders are given within 90 days time. Because otherwise, I jokingly say, instead of right to information, becomes right to history.
true, true, sir. And nowadays, sir, it happens like, goes for more than 1 year also. That,
Which is
but
unacceptable.
again,
It's completely
definitely, sir. But
unacceptable.
again, true, true, sir. Thank you very much, sir. Look forward to seeing you in future. Thank you, sir.
Thank you. Goodbye to all of you. And now feel like the kings or queens of India. Goodbye.
Thank you. Thank you, Payal, and thank you, participant, for joining. And see you tomorrow. Good night. Thank you.